Good morning, friends. Today's topic is Doctrine of Ultra Vires or Judicial Control over Delegated Legislations. My name is K. Umeshwara. In this topic, we will study what is the meaning of ultra vires, what is the reason behind this doctrine, different kinds of ultra vires, what is the meaning of substantive ultra vires, and what is the meaning of procedural ultra vires, and kinds of substantial ultra vires and procedural ultra vires. Now, doctrine of ultra vires. What is the meaning of ultra vires? Ultra vires means beyond power. An act is done in excess of authority. The delegated legislation becomes ultra vires when it goes beyond the scope of authority. When statutory procedure required for making the subordinate legislation has not been complied, if there is a proof of non-compliance, then court can declare such legislation as invalid. Which are all the powers covered under doctrine of ultra vires? All the statutory powers are covered by the doctrine of ultra vires. Doctrine of ultra vires is applicable to private and public bodies also. What is the reason behind this doctrine? You know, there are legislature, judicial, and executive. They are the three organs of a state. What legislature do? Legislature makes legislation. They legislate the statutes. What is the function of the executive? Executive administers the statutes. What is the function of judiciary? Judiciary, it is interpretation of statutes. Sometimes each organ may override and enter into other wings with or without permission. This is one of such overriding. What is the reason behind this ultra vires? What is the reason behind this doctrine of ultra vires? Courts have the right to declare any law as ultra vires. Courts are competent to interpret the statute on subordinate legislation. In this way, courts control the legislature power of the delegating authority. What court will do? First, court will see whether any statutory procedure complied or not. If there is any proof of non-compliance and if there is a proof, courts declare legislation as invalid. Now, kinds of ultra vires. There are two kinds of ultra vires. One, substantial ultra vires. Second, procedural ultra vires. What is the meaning of substantial ultra vires? Substantive means actual fact, actual law. It is a matter of law. It is a matter of fact. It is a matter of discretion. For example, Parent Act itself is unconstitutional. Then delegated legislation will become unconstitutional automatically. Another example, Parent Act delegates one matter and subordinate misunderstood and it legislates another matter. Then also it becomes ultra vires. So, law made by the delegating authority is unreasonable and malefied intention. These are all the examples of the substantial ultra vires. Different kinds of substantive ultra vires. Where the Parent Act itself is unconstitutional, inconsistency between the Parent Act and delegated legislation, where the delegated legislation is unconstitutional, unreasonableness, malafide, subdelegation, exclusion of judicial review, retrospective effect. These are all the kinds of substantial ultra vires. Now we will discuss one by one. Where the Parent Act itself is unconstitutional. No one can pass a better title than what he has. If the Parent Act itself is unconstitutional, then delegated legislation will automatically become unconstitutional. Inconsistency, where the Parent Act delegates one matter and subordinate authority legislates on another matter, there arises inconsistency between the Parent Act and delegated legislation. Therefore, it will be held ultra vires. Courts may quash it. Third one, where the delegated legislation is unconstitutional, all the statutes must be in accordance with the Constitution of India. If it is inconsistent with the Constitution of India, whether it is made by the Parent Act or Subordinate Act, it is liable to be set aside. Legislation cannot override the Constitution of India. Fourth one, unreasonableness. This rule is based on public policy. The rule is found to be partial and unequal in their operation between different clauses, hence it is unreasonable. Parliament never intended to give authority to make such rules as they are unreasonable and ultra vires. Example, one delegated authority made a rule. It prohibited any person playing music in any public place within 50 yards of his dwelling house. Court said it is unreasonable. Malafide, fifth one. Malafide means bad faith. It is also a good ground to quash the subordinate legislation. It is based on public policy. The malafide must be present on the face of the rule itself. The Supreme Court held that writ would lie where the subordinate authority act with malefides while issuing notifications which cause unnecessary harassment to the citizen. Sixth one, subdelegation. Subdelegation means transfer of legislative power from superior to subordinate authority and from subordinate authority to its subordinate authority. As a general rule, subdelegation is not allowed and it is ultra vires. A delegate cannot delegate. Exclusion of judicial review. In the Parent Act itself, certain clauses are incorporated, like it shall be conclusive evidence, it shall not be inquelled, it shall be questioned in any court, it shall not be called in question in any legal proceedings whatsoever. It gives immunity to them and it is felt by the court, where it is only for applicable to Parent Act. Now the question is whether the same clauses, if incorporated in support of delegated legislation, then will the court uphold it? No. Subordinate legislation could not contain the exclusion clauses ousting the court jurisdiction. Retrospective effect, it is another one. The statute with retrospective effect is not at all valid in criminal law. It is in civil law, it is valid. In civil matters, if Parliament wants, it can make an enforceable with retrospective effect. However, the delegated legislation cannot be enforceable with retrospective effect unless and until the Parent Act permits to do so. Now we will discuss procedural ultra vires. What is the meaning of procedural ultra vires? Parent Act prescribes certain procedures while delegating the power of subordinate authority. Subordinate authority has to strictly adhere to the instructions laid down by the Parent Act. For example, Parent Act says subordinate authority has to publish the draft rules before making legislation. Parent Act makes rule that subordinate authority has to consult with a particular group. Then, if the subordinate authority does not do that, legislation will become ultra vires. If Parent Act says that legislation has to be laid before the Parliament table, if they don't do it, it will become ultra vires. If the subordinate acts violate such procedures, then it becomes procedural ultravirus and act will be held invalid. So examples, publication of draft rules, consultation with particular bodies, laying on table. There are two kinds of provisions. One, mandatory provisions and directory provision. Mandatory provision, it must be complied without any exception. Directory provisions means it may or may not be complied. So non-compliance of mandatory provisions shall invalidate subordinate legislation. Now kinds of procedural ultravirus. Publication. Ignorance of fact may be excused, but ignorance of law shall not be excused. The law must be made to know to the general public. Every government decision, every government's order, every government's notification, it must be transparent and it must be available to the every citizen. Every citizen can question the authority and get the relevant information. The publication of government order, rules, notifications is part and parcel of the principles of natural justice. If the law is made and kept in the almirahs of the bureaucrats, then what is the use? The public will not know it. So, all the orders must be published. Order can be placed in the internet so that it can easily reaches the people. Consultation. While making the law, subordinate authority shall consult with the persons whose interest is affected by such subordinate legislation. It is one of the measures to check the control the subordinate legislation. It is valuable safeguard against misuse of legislative power by the subordinate authorities. If the subordinate authorities doesn't do that, then the act will become ultra vires. Laying on the table. It means Parliament authorized the executive to make legislation. The law made by the executive or subordinate authority shall have to be submitted for the verification of the Parliament. This process is called laying on the table. If the delegated authority failed to do this act, then act will become ultra vires. Thank you. The end.